Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law. And this will be what we're commenting on today. Today, we have an interesting opinion from the 4th District Court of Appeals of Florida interpreting the Fourth Amendment in the context of a Facebook records search. It's pretty interesting, and the downstream effects of it are perhaps even more interesting. So let's take a look, first of all, at what the Fourth Amendment says, because it's always good to start at the beginning. Here's what the Fourth Amendment says: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. That's really important because in this particular case, there are two warrants, one of which was ruled to be without probable cause, and the other was in an unrelated case. It's pretty interesting. So, this is the case of Larry Darnell Young versus the state of Florida. It says Darnell Young here, Larry Darnell Young, appeals his convictions and sentences for manslaughter and attempted manslaughter. He contends the trial court erred in denying his motion to suppress Facebook records obtained through a warrantless search, arguing that the trial court wrongfully applied the good faith exception to the exclusionary rule. We agree and reverse. It's fairly rare to see the good faith exception to the exclusionary rule not be upheld on appeal. A young girl was tragically shot and killed by a stray bullet from a nearby altercation while she and her parents were sitting in a car. I would point out to you that it's the innocent bystanders, it's the looky-loos who often wind up getting hurt in these situations, which means that when someone pulls out a gun, it's not the time to observe, it's the time to get away from there and get behind something hard. The appellant's girlfriend, Keosha Karn, and her aunt were having an argument, and she told her aunt that she was going to have her baby daddy come shoot you all. Now, this again is not Mensa level intelligence. You certainly don't rattle before you strike if you're smart or you want to avoid jail. But at any rate, she said that somebody came and shot at the people, and this girl was hit and killed and died. Witnesses identified the appellant as the shooter, but he denied involvement, testifying he had left the scene quickly after arriving because he had children in his car. And he said, "Look, I'm not the baby daddy here. This woman has 5 additional children with 5 other men," which sort of begs the question for why he had a sixth with her, but be that as it may. Appellant and Karn were indicted for first-degree murder for the shooting of the young child and 2 counts of attempted first-degree murder for the aunt and her friend, and 2 counts of attempted second-degree murder of the young child's parents who were in the car with her. After the appellant was identified as a suspect, a Palm Beach County Sheriff's detective applied for a search warrant to search the Facebook account of Stunt Young, who was believed to be the person who they were after. They granted the warrant, but then the trial court suppressed the records obtained because the detective could not articulate his probable cause for the warrant at the hearing. Shortly after the trial granted this motion to suppress, the prosecutor approached another detective with the sheriff's office and said, "Hey, can you get the records from Facebook via subpoena?" The detective told the prosecutor Facebook records from the same account were obtained several months earlier pursuant to a search warrant for retail theft and organized fraud by the theft unit, and that warrant, the theft warrant, was unrelated to the shooting. So through the theft warrant, the sheriff's office obtained these records, and they went from July 7th to December 11th, 2021, the day after the shooting. After notifying the prosecutor of these records' existence and without applying for his own search warrant, the detective searched through these records and reviewed appellant's messaging history, which linked appellant to a phone number that Karn had called shortly before the shooting, which contained a picture of an appellant brandishing a gun matching the description of the gun used in the shooting. So the appellant filed a motion to suppress the evidence obtained during the search through the theft warrant's Facebook records, contending that the detective did not have a warrant to search the records for evidence in the murder case. The appellant argued that the detective needed to secure a second warrant to search the Facebook records for homicide evidence. So the state um, argued that even if the detective was required to get the warrant, the evidence shouldn't be suppressed because there's a good faith exception to the exclusionary rule. So the state really won that argument. The trial court denied appellant's motion to suppress the Facebook records. It found that the detective's warrantless search violated the Fourth Amendment, but the circumstances fit the good faith exception to the exclusionary rule. At trial, a jury found the appellant guilty of the lesser included offenses of manslaughter and attempted manslaughter, and he was sentenced to a total of 40 years in prison. So they appealed. And in this situation, the trial court looks at the factual findings of the court. If there is testimony at the trial or the hearing, the court defers to the trial court's factual findings, but any legal conclusions derived from those facts are held to be reviewable de novo, meaning the court looks at them with no deference whatsoever to the decision that the trial court made. The Fourth Amendment says you have to particularly describe the place to be searched and the person or things to be seized. And if you have a theft warrant, but you're looking for evidence of fraud, and then you use the information obtained from that warrant to solve a murder case, you have to get a second warrant. You have to get a second warrant to cover that search. Even if you already have it in your possession as the agency, as the law enforcement agency, you have to get a second warrant because if you don't, it's going to be suppressed. So this is what the United States Supreme Court decided in Riley versus California. It said modern technology facilitates the storage of large quantities of information on small portable devices. The emerging trend is to require a warrant to search these devices. So the court takes a look at this, and then it takes a look at reviewing the good faith exception to the exclusionary rule. In this case, the detective found the evidence by reviewing appellant's private messages and his private subscriber information, which we find carries an objectively reasonable expectation of privacy. While the detective conducted an illegal search through the Facebook records, the fact that a Fourth Amendment violation occurred doesn't necessarily mean the exclusionary rule applies. To trigger the exclusionary rule, police conduct must be sufficiently deliberate that the exclusion can meaningfully deter it, and sufficiently culpable that such deterrence is worth the price paid by the justice system. When police act with an objectively reasonable good faith belief that their conduct is lawful, the good faith exception applies. The state makes this argument that there's lack of binding precedent, so on that basis, the detective could have a good faith basis to believe that his conduct was lawful. But the court says, look, while an officer may reasonably rely on firm, binding precedent, that's Carpenter versus State, the officer can't rely on an absence of precedent because that's not evidence of good faith. Without legal precedent, the trial court found that the detective reasonably believes the theft warrant authorized him to search. To determine whether the officer had an objectively reasonable belief, the court must assess whether, given the totality of the circumstances, an officer armed with the information possessed by the officer who conducted the search would have believed the warrant valid. So then they come down here and they look at two things: the commission element, in other words, to get the search warrant, he has to have two elements: the commission of a crime, that a particular person committed a crime, and two, the nexus element, that the evidence relevant to the probable criminal activity is likely to be located in the place searched. A search warrant must contain a particular description of the items of property it authorizes the detectives to seize. And in this particular case, the Supreme Court has commented that the particularity requirement stands as a bar to exploratory searches by officers armed with a general warrant. So the theft warrant is more of a general warrant because it's looking for fraud. And now you're using that evidence obtained in the fraud investigation to solve a murder. And you can't do that without a second warrant. So they look at this Michigan case, People versus Hughes, where essentially a warrant authorizing police to seize and search cell phone data allows officers to examine seized data only to the extent reasonably consistent with the scope of the warrant. And of course, the theft warrant didn't include the scope of murder. Turning to the defendant's case, the Michigan Supreme Court held that the armed robbery search did not meet the test because the drug trafficking warrant made no mention of an armed robbery. And they go down and say the prosecutor argues that the good faith exception applies because he was acting in good faith on the warrant. However, the search of the cell phone data for evidence of armed robbery was not authorized by the warrant, and therefore the officer was not relying on the magistrate's finding of probable cause. In this case, the detective testified that after the motion to suppress the Facebook murder search warrant was granted, the prosecutor inquired about getting the Facebook data with a subpoena, and the detective informed the prosecutor that they had these records already. Thus, the prosecutor knew of the existence of the Facebook data was subject to a prior unrelated warrant and knew that the court had suppressed the data compiled pursuant to a warrant in the instant homicide case. Thus, like the illegal search in Hughes, Detective Evans' search was conducted at the prosecutor's request and was therefore attributable to law enforcement and not the neutral magistrate. So they conclude that the theft that the warrant, I mean, it's clear that the evidence should have been suppressed with respect to the good faith, that's not a particularly valid reason to exclude this. And then when they get to exclusion as a deterrent, they say the prosecutor argues there's no police conduct worthy of deterrence because at the time of the search, no court had held a second search warrant was necessary. But that's bogus. And that's because the deterrent benefits of exclusion outweigh the societal costs, because exclusion reminds law enforcement officers that warrantless searches are the exception to the rule, and this exception should only be used when specifically authorized by law. The rule on searches in questionable areas of law is simple and unequivocal: get a warrant. Likewise, we find that applying the good faith exception here would incentivize warrantless searches under unsettled areas of the law. And then the last thing they look at is harmless error, because if this error was harmless, if it didn't affect the jury verdict, if in other words, if there was enough evidence from which a jury could have convicted this man absent this evidence, well, then it's harmless error. And we've gone through all this and said you can't do that anymore. Bad dog, no biscuit. But you're not going to get this reversed because it's harmless. Well, here they say the Facebook records were important to linking the appellant to the phone number which Karn had called after making threats and calling her baby daddy, considering appellant is not the only father of her children. So they say, look, as a result of that, the state can't prove that this error was harmless, and we're going to suppress the evidence. Although the trial court correctly concluded the detective's warrantless search through Facebook records violated the Fourth Amendment, the court abused its discretion in applying the good faith exception to the exclusionary rule. Now, there's a good reason why this is so important. It's because a lot of times, particularly in something like a murder investigation, police are apt to take shortcuts. They know exactly what they need to do, but for whatever reason, they don't do it. And so that's why the exclusionary rule needs to come into play. But here's sort of the inside baseball on this particular case. So here's the interesting part of this. The girlfriend, the one who called her baby daddy and told him to shoot it up, well, that a different jury convicted her of murder, which is, of course, a much more serious crime than attempted murder. And they sentenced her to life in prison. Now, Young, the first time around, had only been convicted of manslaughter. And as a result, murder is no longer on the table because a jury found him guilty only of attempted murder and manslaughter. As a result, they can't get him for anything other than manslaughter in a retrial. So the prosecutor has to weigh the requirement of taking this case to trial again, whether or not it's even worth it, because they can't use the evidence that was suppressed. Now, maybe they have enough to prove what they need to prove. That I don't know. But certainly it is riskier to take this case to trial after it's already been reversed once. It is always a good thing. It's a good day for justice generally when the court upholds the Fourth Amendment's requirement for particularity in a search warrant, and it denies the application of the good faith exception when the police officers, essentially argue, I didn't know the gun was loaded, the sun was in my eyes, there was another party going on and I was listening over there, I wasn't paying attention over here. All the excuses that are made for when people deliberately act to violate the law. And I think that's fairly obvious here, since the first warrant was suppressed for lack of probable cause, that they knew they needed to get another warrant, and that they couldn't base the probable cause on the stuff that was obtained from that warrant. So this is another one of those situations where the court looked at this very carefully and reached the right conclusion. So that's what I have for you today. Thank you so much for watching. If you have any questions, drop them in the comments down below. You can email me at the address above. Like, share, subscribe, all that stuff we always ask you to do. Do a kindness for someone today. Today at the medical office where I sometimes volunteer, the doctor came in and brought in a big pot of Cajun bean soup, and it was wonderful. Just a kindness that she does for the people that work with her. And that's the kind of thing that makes people want to do good for other people. And I like that. That's one of the things I love about her. So, again, if you have the opportunity, pay it forward. And then come on back down here tomorrow. Join me down here at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.